Hi friends from around the world, the invisible trademark infringement, that is our menu for today. Are you intrigued just a little bit? Well, it is not about the, I don't know, the Cartier, watch or the Gucci handbag and knock off product and then, well, you compare one and the other. And this is the infringement invisible. Is a bit different here, and that is what we want to talk about. So there are two situations I want to discuss with you. The first situation is, the keywords. If you search in the engines, the Google search or the Yahoo or whatever you use, then you put some words into and you expect afterwards the results, and well, you may find in the results on the top some results which you were not asking for, and these are the ads, right? Well, you know all this. I do not need to go into the details. So these ads were based on certain keywords. These keywords have been chosen by, the firms, the companies which are behind these ads, right? They defined the keywords, they give it to Google, they made the contractual commitment to pay for clicks or whatever, and then Google puts it into work, into operation, and the algorithm captures what is your keyword, and if it matches the one of that company, well, it goes at the first place. So that is how it is working, right? Now, what happens with this? Well, it may be that the competition, it has to do with whatever you were looking for. So you are looking for Nike shoes, and they have licensed Nike shoes, whatever. So that would be okay, right? Or if they say, I'm not at all with Nike on their website, that is could be considered as fair competition. So it is not an infringement. So what I want to say here, it is not black and white from the outset. It depends on the circumstances, as it is often the case. Therefore, you need the lawyers. This is the first situation. We have a second situation with regard to meta tags. Now that is a bit less, you may not have heard it, that's a bit less obvious. Each website has a kind of meta tag, which is a kind of resume of what the website is about. That starts with meta, is embedded in the HTML. We will come to an example afterwards, just a minute. But it is embedded into the HTML language and not easily accessible. But at the same time, the company behind that website, they may have embedded trademarks from other companies without any permission to do that. And then again, the algorithm captures the meta tags to a certain moment. Well, it comes into the mix when the search engine makes their decision, and with that meta tag, it may be that again it appears on the top of the list of Google, Yahoo, or whatever you are using. So it is also a kind of bringing so to say, the algorithm to on the false track in order to get some advantage on the search results. And again here, it is not as black and white, that also it may depend, and I think it depends on the previous situation or the assessment of the previous situation. We'll come to that. Now let's have a look to the first case, so the keywords case, and we have some judgments. I will talk about two judgments from the European Court of Justice. The one here on the screen is from 2010 and involves, in fact, three cases with a referral court from France to or with more than one referral court from France to the European Court of Justice, and involved advertisers and involved trademark owners. But not only the advertisers, also the search engine. In this case, it was Google. Well, the case is so-called the Google case, the landmark case, so very easily to be commented on internet. So what happened here? The trademark owners, they were the plaintiffs, were against the advertisers and the search engine. They were successful in the first instance, and in the second instance the questions were referred to the Court of Justice on what are the conditions for liability of the search engine and the advertisers. Now, what did the European Court of Justice say? Well, it was the first big case on that, and there were three different cases which were bound together, which made it that the Court of Justice had to make a sound judgment on how to see these cases. Well, first, with regard to Google, the article which is determining the liability was Article 51A of the Trademark Directive here on the screen. And there are, two, but in reality three conditions which are being judged by the court. The first is use in the course of trade. The second would be in relation to the goods and services, so the identical goods and services. And the third, which is not really said in the article, but it has a logic inside which says, only if there is an adverse effect with regard to the plaintiffs, to say the trademark owner. If there's no adverse effect, so why would he go to to the judge, right? Now, with regard to Google use in the course of trade, well, as I said before, it is in the sense that the advertiser, they gives Google the keywords, and Google does not make any investigation whether the advertiser is the owner of that trademark or has the license to use that trademark. They do nothing. They are interested in their business, right? So they want to have a business, and you get the trademark. Okay, the trademark is okay, and they go on and pay for the click. And even if that was recognized by the European Court of Justice, even if Google is taking money in for that, it is not using the trademark in the course of trade. So it gives, so to say, the infrastructure for the advertiser to act upon, but it is not using itself as Google the trademark. It sounds a bit like safe harbor, that from the copyright. Well, it's like this. So it is comfortable for Google, and even more comfortably though, in the case if they say imitation of or copy of Gucci or copy of whatever, Yves Saint Laurent. So that is, so to say, a Google-friendly jurisdiction from the European Court of Justice. Now, what happens in the same Google case with the advertisers? What are the conditions for getting liability from the advertisers. Well, again, we're going through the three assessment stages: use in the course of trade, that is clear. The advertisers, they want to attract some traffic from the internet due to the use of trademarks which they are not allowed to use. So that is use in the course of trade. In relation to the same goods and services, well, A is the 5.1a is with regard to identical goods and services, and the 5.1b is with regard to likelihood of confusion, so similarity, etc. Well, that was here the case. One was, in fact, one of the plaintiffs was Louis Vuitton. So that was clear. Advertisers, they used the trademark in relation to the same goods and services. Now, what is it about the adverse effect on the trademark? Well, this is really the confusion part, so the caveat, which is making that only if there is a, that trademark is about confusing of the public. So this is about confusing of the public. If the public is not confused, then you wouldn't have an adverse effect, right? So this adverse effect is with regard to the function of the trademark. And the function of the trademark, there is one function is the function of the origin, so the source of origin. But there are more functions of the trademark, and the other one being the advertisement and the investment protection, so if you want. But they say, well, that was about the reputed mark, Louis Vuitton. They said, well, that is adversely affect, and then the exact circumstances, that must be the national court which has to assess the factual circumstances of the case, right? But this was the ruling, so to say, from the European Court of Justice. So there's that was in 2010. Now in 2011, there was another case, referral case, which went to the European Court of Justice here on the screen, and it is called Interflora case. And it is about, the same thing, is about keyword Interflora from an advertiser who has nothing to do with Interflora and has no license, whatever, to use Interflora. So it went again through the use in the course of trade, yes, and in relation to the same goods and services, yes. So that was the case of, Interflora to compose some bouquet and deliver it to your house somewhere else, anywhere in the world through the internet. Okay, so this was being said, yes, well, that was the case. And then we had the adverse effect. And here it went a bit more in detail. The Court of Justice went more in detail, and basing it on the previous Google case, which we discussed before. And they were saying, well, the trademark function can be adversely affect in all its aspects. All its aspects, meaning the source of origin, the investment, and the advertisement function of the trademark, protected trademark. And it precised also, and that was not so clear from the previous Google one, that these three functions of the trademark, they have it for all trademarks. So the trademark must not be reputed in order to have these three functions covered. So all trademarks have these three functions. One, the essential, is the source of origin, indication of origin, and the other ones are being, the additional ones, so to say. So these are the the two cases, well, in fact, there were 4 cases on the keywords. Now, what happens with the meta tags? I didn't find any European Union Court of Justice ruling on that, but I may think that we can see where it would go once it would come to the Court of Justice in the light of what we have seen in the Google and Interflora case. So what is the meta tag? Here on the screen you have one meta tag, so imaginative meta tag for a sofa maker, for example. So that is a short sentence, as you can see, well, not really a sentence, but short sequence of words, which starts with meta and is embedded in the HTML codification of the web page, right? You can look this up, so there are possibilities. Those acquainted with internet, well, you can look this up in how is the meta tag. Now, what happens with that meta tag if you put, I don't know, for watches, and you put Rolex, you put Hublot, you put Cartier, and everything else into, and that would your watchmaker, right? And that would bring people to your website. Your website through the algorithm. The algorithm would pick on these words, meta tags, in order to put you on the front of the result page. Now, what would be is it black and white? No, it is not black and white. So if you come to the website now, the website which you are lured to see, right? If you come to that website and that website says, well, I have nothing to do neither with Hublot, with Cartier, or with Rolex, then, well, you are not confused, right? So there would be probably no problem. That is part of the fair competition, but you should know it, that this kind of fair competition, so to say, exists. They are using your trademark, but you're not adversely affected in order to build up on the argumentation we have seen just a moment ago. If, on the contrary, you make clear that you are licensed from Rolex, you have a link, a connection, you are a branch of them, you are an authorized dealer or whatever, and you are not, in reality, well, then the situation changes. So you may come into some difficulty, or the owner, the trademark owner, they will bring you into some explanation mode, so to say. Now, just a last remark. What do you do in these cases where you think there is something in for you, or there is some infringement with regard to your protected trademark? Well, the careful assessment is the first thing you should do. That is normal. And then eventually, if you see there is something which you don't like, there is an infringement case, then you would make a cease and desist letter, you know this, and eventually afterwards you would go to litigation. These are the classic possibilities, or if not, you may want to negotiate a different outcome for the sake of a quick settlement. Thanks for this time tuning in.